Earlier this month, the Valley Lookout reported on a federal lawsuit from several major publishing companies and authors, as well as individual Idahoans and a public library district seeking to overturn the library materials law that took effect last year, also known as House Bill 710. Associate producer Logan Finney visited the Donley Public Library earlier this month to see their one-room facility and ask why they decided to join the lawsuit.
Thanks, Melissa. Since July, Idaho state law requires all school and public libraries to offer a relocation form for patrons who believe specific library content contains obscene material that is harmful to children. If a library does not act on a request within 60 days to move materials to an adults-only section where minors cannot access it, then the requester can sue the library for $250 and statutory damages. It took over 3 years of legislating, including a failed veto override, for Governor Brad Little to sign a bill addressing lawmakers' concerns with public libraries.
They can have the material, and that was what was discussed over the last several pieces of legislation. Are we banning books? Are we removing books? No, we're not. We're codifying a relocation policy.
Kootenai County Sheriff Bob Norris said he was shocked and disturbed at some of the books available to youth at the local libraries. He's been hanging on to the copies. He'd rather pay for them than give them back.
Just relocate the stinking book. That's all you got to do. If there's a question about the book, why are we fighting so hard to put obscene material in front of our children? Why?
Per the Spokesman Review, the Community Library Network in Kootenai County established an adult-only mature content room and revoked minors' ability to make requests on interlibrary loan. The Meridian Library Board voted last week not to move a picture book that features a prince falling in love with a male knight.
I would encourage the community to use this process for legitimate concerns rather than an outlet for sort of expressing opinions or biases. Not a good use of our volunteer board's time, and it is certainly not a good use of taxpayer funds.
The Donnelly Public Library in Valley County designated its entire one-room building adults only, and last month it joined a federal lawsuit against the state seeking to undo the new law.
To think about putting all of my adult books in like a locked cabinet, that's half the library. There are books that are for adults that are in our library, and those adult books are within a foot of our children's books. Saying it's an adult-only library, is it weird? Yeah. But also to talk about locking books up and putting warning labels on them, to say that we should just eliminate the pornography, that also sounds weird because we absolutely do not have pornography. We didn't have it before HB 710 and we don't have it after HB 710.
The library and several individual Idahoans are plaintiffs alongside nationwide publishers who've already honed their approach, challenging similar laws in other states.
We started in Iowa. It's a very similar law that blockades titles that have references to sexual content. And that means a single reference. A contextless snippet from a book-length work is enough to render it on the banned list. So we challenged that law. We followed that up by challenging a similar law in Florida. And then when Idaho passed this law, it's almost like a hat trick. It's really similar. But in some ways, it's an expansion because it applies also to public libraries, not just school ones.
We don't have a bookstore here in Donley. We don't even have a grocery store. The list of things we don't have is huge, but that doesn't mean that our nearly 3,000 library members shouldn't have access. If you can't find it at the Donley Public Library, where are you going to find it?
The lawsuit requests an injunction to halt the law's enforcement while the case is in the courts.
That's an extraordinary ask, and it's only appropriate in circumstances where the harm is really great and the likelihood of success is very high. We're talking about the works of Toni Morrison. We're talking about 1984, books about the Holocaust. It's not just fiction, it's nonfiction. It's not just historical nonfiction, it's contemporary. So it's hard to hear this belief that the shelves of Idaho libraries are replete with pornography because we're not in the business of selling pornography.
Not just HB 710, I believe laws across the country are disproportionately impacting small and rural libraries simply because we don't have the means to necessarily accommodate every single line of the legislation.
What happens, I think, is that certain books were originally written for older audiences and are quite appropriate for older library patrons, you know, we're talking 17, 18 years old, might not be comfortable or the right fit for a younger reader.
That's one of the things about the lawsuit that is important, is what is okay and acceptable for a 16, 17-year-old may not be for an 8 or 9-year-old, but that doesn't mean we remove it.
Shaline is grateful to have the backing of her community and the publishers for the library district's fight.
I 100% believe it's the right decision. I had a librarian in Northern Idaho. On the day that the lawsuit was announced, she called me and said, "Thank you." And she said, "It means so much to me because I feel like I've had a foot on my throat." It just breaks me. The fact that librarians are fighting so hard and that so many of them are being silenced. It's stories like that that make me happy that I have such a strong library and I have such a great library board. It's just now that people are coming in with these challenges. Just this weekend, I watched a video on how to go about challenging a book in these libraries and like encouraging people to challenge these books.
Any issue that a parent has with their their youngsters reading should be resolved on the basis of that parent's concern, rather than having free-floating censors running around and deciding what other people's kids should be reading.
Nobody's coming in and checking out pornography. Pornography is a billion-dollar business. A billion-dollar business. If we had porn in the library, we'd be paying our librarians better, and by God, I wouldn't be talking about needing a bigger building. This is ridiculous.
There are really well-defined canons of judicial doctrines, we call them, that say, here are the rules for the road when you're deciding things on the basis of obscenity. And that's what these cases are about. This is all about labeling something as pornographic or obscene. It has to lack serious literary, artistic, political, or scientific merit. That is a decision that local librarians and educators make. And if you don't allow them to make that consideration, this is what you get. You get mass banning of books across the board. We're going to put that all in front of the court and figure out whether or not this law merits a blockade at the early stage.
The big publishers are, it's the big five. And it's, for that, I'm appreciative.
Bill sponsor, Representative Jaron Crane, told Idaho Reports that the law is constitutional and the legislature would make any adjustments deemed necessary by the courts, but he declined to comment further, citing ongoing litigation. Attorney General Raul Labrador and attorneys for the other defendants filed motions to dismiss on Wednesday, citing a lack of standing and evidence of actual injury.